Good day. I'm your lecturer. I'll be taking you on debt recovery, methods for the recovery of debts. My names are Timothy Abiodun Olatokunbo Chubiele. I was called to the Nigerian bar in the year 1980. I have since then had the opportunity to practice law, to teach law. I started my legal practice with the law firm of JMO Oyetunde in Jos, Plateau State, Nigeria. I've also had the opportunity of lecturing at the Nigerian Law School. I have facilitated and organized seminars on debt recovery and labor laws. I'll be teaching us today on part 1 of methods of debt recovery. Debt recovery is a specialty in law. It's needed in the people must have understanding of debt recovery in the banks and in the financial institutions. If debts are not recovered, a business can fail. And we cannot rule out the issue of debts because people must borrow. They must borrow to facilitate one project or the other. Some borrow, and because of economic and various problems, they are not in a position to pay back, but they must pay. Some borrow with the intention of not willing to pay back. But debts must be recovered. So I will be teaching us on methods for the recovery of debts. One of the methods for the recovery of debts is the threatened and actual publication of name of debtors in newspapers. This method has worked. When there is a threat that the name of a debtor will be published in the newspaper, most of them will run to the financial institution to make an arrangement for the settlement of the debt. But whose name do we publish? In the case of limited liability companies, some of these companies are no longer physically in existence. Since the time credit facilities were obtained, these companies are no longer operating. The money that was borrowed has probably been diverted into other projects. Is it the names of the directors that we will publish? So this creates some problems. There is the fiduciary relationship between a banker and a customer. Should a bank go ahead and publish the names of his customer as a debtor? So these are things to be pondered on in the issue of publication or threatened publication of the names of debtors. There is the use of debt collectors. Some commercial institutions prefer the use of debt collectors. They are said to be very effective in the recovery of debts because of their unconventional attitude or unconventional methods in the recovery of debts. It's only recently that I learned there's an association that is regulating the conduct of debt collectors, and that this association in Nigeria, for example, is linked to an international group. This is a welcome development. Either to all sorts of people come out to practice as debt collectors. Their practice is not regulated. Some of them are just thugs. using very unconventional methods in the recovery of debts. A debt collector will approach a debtor, threatening him that he will sell his house if he does not settle the debt owed the bank. What will the debtor do? He will rush to the courts to obtain an injunction to prevent the bank from selling his house. And in that particular case, he did not even mortgage his property. I did a case like that for a particular bank. He never mortgaged his property. It's just a waste of time, because the debt collector proved not to be knowledgeable in his work. Some employ thugs in the recovery of debts. A thug who involves himself in criminal liability in the recovery of debt is personally liable for the crime. The principal who instructed him cannot be vicariously liable for that which is criminal. But if a tort is committed in the process of debt collection, the creditor, who is the principal, can be liable vicariously for the action of the agent. Many debt collectors are known to be illiterates. Some of them semi-illiterates without experience or knowledge of relevant laws guiding commercial transactions. So these are the advantages and the disadvantages of the use of debt collectors. Another method some people embark upon in the recovery of debts is the detention of debtors. There is the problem of who to detain. In the case of limited liability companies, do we detain the directors? If we detain the directors, this will offend the common law principle of the limited liabilities of companies being a legal entity separate and distinct from its proprietors. There are so many cases on this. Salomon and Salomon, Kano State Oil versus Elliott Producers Limited and Kofa Trading Company, Ayegunan versus Osaka, NNB versus Bazunu. There are so many cases. Agbomagbe Bank versus GB Olivant. There are so many cases in this respect. Who do we detain? Debt recovery exercises should not involve the detention of the debtor. Can an individual go and detain another individual because of a debt? This will cause a breach of the peace. So what do creditors do? They employ the services of security agents, most especially the police. In Nigeria, for example, there are so many cases where it has been reported that the Nigerian police should not be employed in the settlement of private grievances. Debt collection is a private grievance. It's not the work of the police. And reference is made to Section 4 of the Police Act of 2004, Laws of Federation. A creditor may be sued for unlawful detention where he expressly directs the police to arrest and detain a debtor. I will speak more on the subject of detention of debtors. There's the realization of security. Many creditors, when they are giving out credit facilities, will insist on the person applying for facilities making securities available. It could be mortgages, debentures can be created, But one finds out that when the creditor wants to foreclose on a mortgage, many debtors will rush to the bank to file frivolous actions to gain time in the settlement of debt, incurring more expenses in legal fees to the creditor. Most of these cases are frivolous actions, but a frivolous action can be in court for so many years, and the creditor will still be funding, paying solicitors' fees, paying the fees of counsel in respect of a debt. Then there could be the problem of failure to obtain governor's consent to mortgage landed property. It takes quite some time in most of the states in Nigeria. And without governor's consent, a mortgage will fail. And it takes time. The creditor has a project he wants to embark upon. He does not have the time to wait before governor's consent is obtained. So what most banks will do is that they will just collect the title documents, and that will only create an equitable mortgage. So if the debtor, the person who borrowed money, defaults in payment, he will still have to go to court for leave to dispose of the mortgage property. And going to court in most Nigerian courts does take time. Even when there is a perfected mortgage, there could be difficulty in finding buyers for mortgage properties. For example, because of superstitious beliefs, fraternal feelings, there could be difficulty in finding buyers for mortgage properties. People will say, who will buy the property of the son of the Oba, or the son of, or if the debtor is a chief, who will buy the property? So there could be problems like that. As I said earlier, requirement of governor's consent in respect of property, it takes time. And it's a requirement as posed by the Land Use Act. So these are the problems associated with the realization of security. Another method in the recovery of debt is what participants in lectures like these that I've conducted in time past have classified as the end justifies the means approach. That means you can use any available method. The most important thing is to recover the debts. Perhaps when recently bank officials went and besieged the house of a senator to embarrass him, is justifiable as one of the end justifies the means. They did not commit any offense, but there were videos which we saw in social media of how bank workers surrounded the gates of the premises of a debtor who is a senator in the Federal Republic of Nigeria. Going back to what I said earlier, the use of police, state security agents, the Economic and Financial Crimes Commission in the recovery of debt. As I said earlier, it is wrong. Some people will come up with trump-up charges in order to recover a debt. A creditor can make a complaint to the police that the debtor is threatening his life. Based on that, the debtor can be arrested, and the police or the security agents will ensure that he makes a repayment proposal of the debt. After he makes the repayment proposal of the debt and he makes some payments, he will be set free on the trump of charge. This is wrong. But a debt can be criminalized. This looks like a welcome development. How can a debt be criminalized? Right from the time, from the onset, when facility is given out to someone who applies for facilities, he can be asked to do a repayment proposal. How will he pay back the facility? And that this proposal will be supported with checks will be honored as so and so date. If the check bounces, that is an offense. A debtor can be approached and asked to make a repayment proposal supported with checks. At any time when this check is presented for payment and it bounces and payment is not made on the check, then a charge can be preferred against the debtor. Look at Dishonored Checks Offences Act, Laws of the Federation, year 2004. So, these are ways in which a debt can be criminalized. There are other methods that we call the end justifies the means approach. There is a psychological method in debt recovery exercise. There is the woman psychological approach. Some financial institutions are known to employ the services of women to scout for deposits. These same women can be employed as debt recovery personnel. Men are said to have their own ego. So, it is believed, it has been suggested in various seminars, that women can be sent out to speak to male debtors. And because of the ego of the male, some of them will be forced or will be made to settle the debt owed. There is the mystical and diabolical method. I'm not an expert in this area, but one cannot rule it out. And maybe by way of mysticism, a debtor can be made to pay a debt. Maybe juju, witchcraft, whoever believes in such. Charms can force a debtor to pay. I don't have experience in this area, but I read a book a couple of years ago, written by a lawyer, the late Justice Adewale Thompson. In his book, Reminiscences at the Bar, page 98, the author, a former judge and attorney general of Oyo State, stated his experience on the use of charms. He said he went to take possession of the property of a fetish witch doctor, and he fell sick for 6 weeks after the exercise. So perhaps some of these fetish practices can be invoked on a debtor so that he will pay off the debt. Whoever believes in such, perhaps it works. I don't have personal experience in such areas. Security for advances of credit facilities, fixed or floating assets of the debenture of the debtor, guarantees, life policies, stocks and shares, promissory notes, mortgages, cash and savings account, pledges, domiciliation of contract proceeds, trust receipts, bills of sale, endowment fund, hypothecation of goods, and negative pledges. And such similar can be used to secure debts, which can be used in settling the debt. Guarantee agreements, which must be in writing. The creditor can ask the guarantor to settle the debt when the principal debtor fails to pay. But one must be very, very careful. The creditor or the person who gives out the facility must be very careful in the way he couches the guarantee agreement. A guarantee agreement should not be limited to the principal. Right from the onset, a guarantee agreement should incorporate the payment of interest until the debt or the money is paid back. So, I will try and stop here because there are so many other methods to be used. I always ask participants at seminars like this to help us by coming up with other suggestions. I will be asking those who watch this video to join our WhatsApp group, Debt Recovery Lectures. I will be sharing on various social media platforms the links. In this WhatsApp group, you can join us, suggest to us other methods of debt recovery. You can also comment in the various social media platforms where this video will be shared. We want people to be knowledgeable in the recovery of debt. We will appreciate if you share this video. You must have a knowledge of debt recovery. Debts must be recovered. And when the economy is down, there's so much work to be done by debt collectors. Collection of debt is not limited to lawyers alone. But it's just that we must know how to recover debts. Various banks have debt recovery departments. This lecture, I believe, is a welcome development. You must have a reference book. I recommend this book to you. Debt Recovery, Laws and Procedure. This is the 4th edition of this book. The book was first published in the year 1996. It is the book on debt recovery. You will have forms and precedents, letters, and how to go about recovering debts. I recommend this book for you. Look out for it. And if you are not able to get this book is also in the Law Master digital law research platform. We have the Law Master Mobile and the Law Master Unlimited. You can make inquiries about these digital platforms. You have not only the book on debt recovery, we have about 10 books that I've authored. We have law research materials, law reports, digest of cases. There you will be able to find about 6 other books that I've authored, edited, and published on the subject of debt recovery. Thank you for listening to me.